It's great to have as our next guest Peter Myerson. Peter is a frequent contributing guest, and Peter's a senior partner and founder of co-founder of Cohan, Rasnick, Myerson, Plaut, LLP. Peter, great to be with you.
Mark, it's wonderful to be here. I love your suit. It's really a good one.
Peter, I was going to have a positive interview with you anyway. You didn't have to flatter me, but thank you. I appreciate it. Well, Peter, you always come in with great legal subjects, and as a lawyer myself, I really appreciate your nuggets of wisdom. And one of the subjects is near and dear to my heart. I know near and dear to your heart is fiduciary duty of lawyers. And I'd love you to expound upon that in today's discussion.
Yeah, that is something which I feel kind of passionate about, and I think that clients don't really understand what that duty is, and I think lawyers in particular frequently don't understand what that duty is and don't understand the practical applications of it. And although I've once before kind of given an example of how this sort of became current for me, I'll tell the story again. I had a new client come in recently, and he was an interesting guy, a very senior person in a professional service business, and he had been terminated from his prior employer, and he came in and he wanted me to look at his termination material,
right,
which I did, and it turns out that he had no contracts with his prior employer of any nature or kind, and he was not he had no ownership interest, which is a quite significant issue in today's world with respect to non-competes, and not only non-competes, but if you own stock
right
in a business, you have in effect a fiduciary duty to your employer.
What about common law? I mean, even though there's nothing formal, but the fact there are common law that if you are contacting, it's like in most agreements. Now, there was no agreement here, but if you're contacting everybody in the company and everybody said, you're right, and, we don't need to be with this person anymore, you're the one that set it in motion, and you've been talking to the people, you've been inciting the people. So isn't there a common law issue here that even though there's no, quote, contract, you are tortiously interfering with the employment of and the business of the company?
No, actually, you can interfere. Well, let me go back a step, because my practice is not litigation.
Right.
I mean,
well, your firm does litigation.
My firm does.
You work with a lot of corporations.
Yeah, I work
right.
with a lot of corporations, and my partners, one of my partners tried this other
Correct.
case, and we do a lot of contingent fee litigation
right.
for businesses,
right.
which is fairly unusual. In terms of the common law and tortious interference, the cases are pretty clear in Massachusetts that you have to have an intent to harm if you're going, if you interfere with somebody else's contract. And just trying to run a business or trying to set up your own business is not a tortious interference. Clients really need to, when they're coming in, need to ask that question
right.
when there's a single lawyer representing a group.
Right.
And it's very difficult for the first guy, who I really like a lot. I actually like the second guy and the third guy. I mean,
right.
they're all very nice people.
Right.
But I sat with them in this is not the kind of conversation you have over a phone. You sit with them in a room and you say, look, guys, this is the law. If I represent the entity, I represent the entity. Now, it doesn't mean that I can't, do all the things that I need to do. But if there's ever a dispute among any of you, or if one of you thinks that you need to, take some action against the other one, I just can't be involved.